docket. That is case number 105995, State of Kansas v. Chris King.
Good morning, Your Honors. I'm Reed Nelson, and I'm representing Mr. King. Chief Justice, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Mr. King was convicted in this case of a number of counts of sexual abuse against R.B., and of course this is a direct appeal from those convictions. He received a life sentence. And I'd like to discuss 3 issues today. They're not in the same order as they're presented in the brief. First, I'd like to discuss the unanimity instruction, the lack of that, and then I'll talk about the exclusion of this child's prior allegations against others who did similar acts to her, she said, and lastly, the admission of Mr. King's prior acquittal for somewhat similar allegations 12 years prior to trial. So first of all, as to the multiple acts issue, the question before the court, I think, is whether this is a true multiple acts case. I think that it certainly was a true multiple acts case. The prosecution presented a complaint alleging 6-month period of time during which these things occurred. They then narrowed that down using a confluence of exhibits of the calendar showing when the child was home during the day, because she said it happened every time she was home during the day from school, and a confluence of when Mr. King was off of work and would have been home. So they narrowed that down to 11 days. Now, if it ended right there, then this wouldn't be a true multiple acts case because there's nothing to distinguish one day from the next. But that's not really what happened in this case. The defense didn't wave the white flag as to those days and say, yeah, he had the opportunity, we concede that at all. They addressed each day specifically. Each day was factually, specifically addressed by the defense differently. And they went right through those dates, November 5th, 6th, 2 dates in December, 1 day in January. And they talked about, there was a different kind of scenario for each day. And I just set those all out in the brief. The McDonald's day when he took the kids, he dropped the kids off at McDonald's, and there would have been very little time prior to that for anything to have happened. The GameStop day when he took the kids to Lawrence, and he said that lasted 2 hours, and he had a receipt. So there was an exhibit supporting that. There were the grandparent days when actually Roxanne, his wife, testified that the kids were at the grandparents. So the defense rebutted each one of those individual days. They're factually separate. And even the prosecution in their closing failed to elect any one of those days and in fact emphasized 2 specifically. The Tickle game day that her younger brother testified he thought they were in the room alone together. And so that relied on his credibility and his observations or his lack of observations about what he saw, because he actually didn't see anything occurring. And they also brought up another day that they emphasized, the January 3rd day when the kids were dropped off at McDonald's. So the prosecution emphasized 2 separate days in their closing argument and didn't elect.
Let me ask. At one point, did the prosecutor argue that the defendant had 11 opportunities to force the child into oral sex? I had that written down. I don't know where I got it.
Right. I don't think that the prosecution ever argued that there were 11 opportunities. I think what the prosecution has argued in its brief is that there was only 1 allegation of oral sex. And so even if everything else, it would be a multiple acts type situation, since the child only alleged 1 act of oral sex, that wouldn't fit in to a multiple acts analysis.
That's what their argument is.
Right.
But I think what my colleague's referring to is that there was a statement during closing argument by the prosecutor where they may have snatched defeat from the jaws of victory because having elected on that, perhaps they said there were 11 opportunities to have committed that particular crime. You're just not,
I
you just
actually
don't
don't
recall
remember
that?
that, but I know that they encouraged the jury to look at the calendar showing 11 different days. And so those days were wide open. And remember, the child in her interview said it happened every day that she was home. So these days were all in play for the jury, and all the acts were in play for the jury. And I just want to make sure that it's clear in the record on this oral sex allegation. In her video, she does say that it happened, and I think the prosecution misread it. It wasn't that it happened one time. At minute 43 or 45, the child says that it happened sometimes, and a little later she says it happened 10 times. So it's not one. Her testimony was once, but the videotape that the jury saw was sometimes and 10 times. In terms of the evidence of issue number 2 is that the defense was not allowed to put on evidence of her prior allegations that juveniles perpetrated abuse upon her prior to this, sexual abuse on her, and the defense wasn't allowed to put in the mother's telling the child about her own sexual experiences. These matters were very much an issue. Her sexual knowledge was very much an issue in this case. The prosecution, in their closing argument, emphasized several times and in different ways, looked at the jury and told them how would an 8-year-old child know how to make these kinds of descriptions if she hadn't lived through this with Chris King. What the prosecution knew, and what the defense knew, but the jury was not allowed to hear, is that there was evidence that the child had such a dysfunctional upbringing. And the jury knew some of that, but they didn't know the sexual aspect of it. They knew that the parents had abandoned their roles as parents and had drug problems, but the jury did not hear, for example, that the mother was sharing specific examples of her own sexual abuse to this child, and the child told her therapist that specific example of sexual abuse.
Wasn't the basis, though, of the judges excluding that testimony was the uncertainty of what occurred? I mean, you speculated that these events took place, but what is the trial court judge supposed to do when it's just speculative evidence? It's not specific. They were allegations and kind of proffered allegations.
Right.
Why should a trial court allow that in when there's not specific evidence of these prior sexual experiences?
Okay, so right. Justice Rosen, you're referring to the allegation she made against the 2 juveniles.
Right,
Okay.
right. And it was the court found it's unfounded. There's nothing there other than the suggestion that it happened. I mean, is that enough to defeat the rape shield statute?
All right. So the detective, it comes in my view, in either event. So the detective in this case, in preliminary hearing, testified that he had investigated her allegation of abuse by these 2 juveniles and found them to be unfounded. Okay, those are his words. And so defense counsel said, well, that should come in for the jury as that these were possibly false allegations, that this child has made false allegations of this similar nature prior to this. And so it should come in for that reason. Alternatively, and I think, Justice Rosen, this is what you're talking about, even if they don't come in to show prior false allegations, if there is some substance to these, then they need to come in to show that she has had certain kinds of sexual experiences that would allow an 8-year-old to actually talk freely about these things. So either way, they seem relevant and admissible under our rules.
Even if the judge deemed them to be unreliable or not supportive. That's Justice Rosen's point.
Well, she made the
If they were
allegations.
unsupported, then they came in because she'd made unsupported allegations. That's your point?
Well, she said it, right? So
Okay.
it's evidence. She said it to her therapist. and other people. It was an ongoing allegation. She said it ongoing. She was receiving therapy after this case. She was receiving therapy by 2 therapists, and it was an ongoing allegation. She told one of those 2 therapists that this happened. So she said it. The therapist knew about it. My client knew about this and told the officers, the detectives, when they came to his door. So there was the judge's ruling, I think, in that regard would be incorrect.
Okay, I'm following. Thank you, I'm sorry. I delayed you a little bit.
And then, last of all, the prior acquittal coming in. Mr. King had been acquitted 12 years before this of improperly touching a 4-year-old. And this ended up, as defense counsel predicted, being kind of a trial within a trial, because they had that child, now more grown, and her aunt, I think, come in and testify. So we raised not only that this violated this double jeopardy because they were trying this again, but in addition, it seems as though the probative value of an acquittal that occurred 12 years ago would be extremely low. After all, an acquittal ought to mean something, and that it would be very outweighed, especially this remote time, by the prejudicial effect, which was monumental, as I point out. Once the jurors during voir dire learned about this, they were ultimately preemptively struck. Numerous jurors were.
I understand your argument, but there is something troubling about a prior acquittal. Seems to exonerate, and why is that even relevant at all? But on the other hand, you can bring in prior allegations or civil wrongs, and that's where it would stand when someone's criminally acquitted, possibly. And what would prevent it from coming in under that rubric?
The prior...
these people made these allegations 12 years ago. It was a civil wrong, and here's the evidence that supports it.
Right.
That happens not all the time, but it happens under these scenarios where there's not a criminal action.
Lots of unconvicted conduct comes
Right.
in.
Yeah.
Yes.
And the burden to demonstrate some probativity is significantly lower than beyond a reasonable doubt in a criminal case.
Yes, I
So
understand that.
how does that play out here?
And I think that the prosecution's point in their brief is well taken. I think they cited some U.S. Supreme Court cases that say we have a different standard involved in these. But look, propensity. This came in for propensity. So defense counsel asked, does one act 12 years ago, is that really propensity evidence? This current one is only an allegation. An acquittal ought to mean something, and that would be the distinction. An acquittal ought to carry some weight, some finality in terms of somebody has left this, behind them, and the jury has made a determination. Generally, we think.
What is the jury determined by an acquittal? It could be that there wasn't enough evidence, or it could be, hey, this guy was in a different state at the time this took place, and there's no evidence that he was even in the. I mean, there's a whole lot of different assumptions you can make from an acquittal that I just don't know what you can.
I
make
understand, but certainly, it ought to affect the probative value.
I understand.
Yeah. So that's our. Yeah.
But you get into the weight versus admissibility, because the jury was advised that there was an acquittal.
That's true.
And so you're
That's
talking
true.
about gatekeeping at this point, and
That's true. And I will just finish on this and point out that there. I pointed this out in the brief. There is an inherent unfairness in allowing that evidence in. Okay, we have an acquittal that is 12 years old that comes in to show Mr. King's propensity to do these things, and yet, on the other hand, this child has apparently made allegations against others that the trial court blocks and does not allow in. I think that there is a parallel to those two ideas. And
His propensity could be proved and hers could not. That's what you're saying?
that's what I'm saying.
Okay.
All right. Thank you.
Counsel, before you sit down, I have a question, just so I'm clear, that our standard of review on your issues 2 and 3 is for abuse of discretion? There are complaints
Well-
about,
Excuse me.
evidence.
Well, that's true. It's about evidence, and I'm only thinking about the opportunities, though, to cross-examine witnesses about these things. So, for example, about these prior allegations, the defense's inability to cross-examine the therapists about this child's prior allegations. So I think that it moves into questions of constitutional rights to cross-examine, to put on a defense, to testify in his own behalf that he's aware of these allegations. So that would go to issue number 2. So yes, an abuse of discretion, but also a constitutional question about limiting his ability to put on a case.
And the standard for reviewing that would be what?
Well, constitutional harmless error is an error, but looked at under constitutional harmless error analysis.
Chapman?
Yeah.
And what about,
And I think that I probably have a similar response for being able to put in, well, no, I think on the acquittal, that probably is an abuse of discretion standard. I would think.
any further questions? Thank you, counsel.
Thank you.
May it please the court, Shirley Marquardt on behalf of the Appalachian State of Kansas. Beginning with the 6455 evidence, there was a hearing where the court required that the state bring in the victim's aunt, and the detective from the previous case, that there was the jury trial and the acquittal. So it was not just either a proffer of the information or a mere motion that was filed for the court to consider whether that 6455 evidence was material and probative. The court actually had an opportunity to see the witnesses, to view their demeanor, to evaluate their credibility. And after that hearing, the court determined that that 6455 evidence would come in, even though there was an acquittal. And the acquittal is not that the act didn't happen, it's that it couldn't be proven beyond a reasonable doubt. The 6455D subsection indicates that it is an act that is permitted if the court determines that it's material and probative, and not whether it was proven beyond a reasonable doubt. The acquittal does not automatically bar the admission of that evidence. Instead, the fact of the acquittal would then go to the weight of the evidence. The jury was well aware that there was an acquittal. The defendant was able to put on that evidence, and as the court determined for the motion for new trial regarding the 6455 issue, the court determined that there was not a lot of emphasis of that evidence during the jury trial. Basically, that evidence was presented through those witnesses for the jury to use for any matter that they thought it was relevant and probative to determine, which is what 6455D says. It can be used for any matter that the finder of fact believes that it's relevant to establish. This was a case of general denial defense. It was, I didn't do it, I wasn't there.
It isn't a simple general denial, though. Your opponent pointed out that there was a great deal more evidence put on by the defense about opportunity on various days, et cetera, on the specific days that were pinpointed by the prosecution. That's not a general denial. A general denial is I didn't do it and nothing else.
And, Your Honor, what the defendant said from the very beginning, from pretrial motions all the way through trial, is I was never alone with her. I never touched her. In fact, I tried to stay away from her. And this was all fabricated because of the victim's mother's not wanting to pay child support. And there was a financial motive for the victim's mother to fabricate this and basically coach or feed that information to this 8-year-old child so that she would make these allegations of sexual molestation. And so the reason why those 11 dates were put forward was because the general denial of, she was never alone with me, I never did this, and it was fabricated. And so what then the state had to do was to establish for the fact finder to determine whether she was alone with him. The way that that was established was she said it happened when she was home from school because there was a holiday or because it was a snow day, that her aunt was at work, and that her caregiver was Chris King. So the way that was established is getting all of those records and, in effect, intertwining them to see where do those dates exist? Where do they occur? So the only reason that those dates were established was because of the general denial defense from the very beginning of, I didn't do it, I was never alone.
So you got evidence together that there were 11 opportunities.
Yes.
And the child testified that it happened every time that opportunity was in place. So you presented evidence of 11 different acts. So why isn't the instruction required or an election?
And that's what's difficult about this case. This is an 8-year-old child who, in her interview at Sunflower House, said it felt like 50 hours. She knew it wasn't 50 hours, but she said, because every time that I was alone with him, because my aunt was at work, I was home from school, and he was my caregiver, it happened. And so she was basically the perfect victim in that both of
Counselor,
her...
my question is, the state put on evidence of 11 times.
Yes.
Potentially 11 acts that would fit within the charged crimes. There could have been 11 convictions. Why? But you didn't charge 11
That's
counts.
correct.
Why isn't that a poster child for a unanimity instruction or an election by the prosecution, neither of which happened?
Right. The difficulty with this 8-year-old child is that these acts, in effect, merge together.
The child wasn't there at the instruction conference. Why?
No.
Why wasn't it error not to have the instruction? The child wasn't there when you gave closing argument and said there's 11 opportunities.
Right.
Why wasn't one of those two done, and why isn't that error that they weren't done?
Right. First of all, regarding the giving of the unanimity instruction, it was never requested by defense. And so if it's not requested, then it's a clearly erroneous standard. That this
Are you
court...
conceding that it was error not to elect or instruct? Let's deal with that first,
Right,
and then
right,
talk about
understood.
harmlessness.
The factual difficulty of whether it's a multiple acts case is the merger in the 8-year-old child's mind of these acts. She cannot tell you it's a specific
So
act,
why
a
was it not
specific
charged
date.
as 11 acts? If she said that it happened 11 times, why weren't 11 charges filed?
Well, she said it happened every time she was alone with him.
And you determined that was 11 times?
I determined that there were 11 opportunities, but I did not believe I could prove it happened 11 times.
How did you prove that it happened on any particular day, if your merger theory is correct?
Right.
I mean, this is the difficulty. That's why that's why we either, if you can't elect, then you instruct.
Right, right.
I mean, you have to do one or the other in those types of cases. So that's what I'm asking you. Do you concede that it was error not to do one or the other?
If the court determines that it was a multiple acts case, it was error not to instruct.
Okay,
That's
thank
correct.
you.
But that's the difficulty in trying to determine.
Generic evidence cases.
Exactly. And the fact is that she testified at the jury trial that each of these acts happened. She disclosed during the forensic interview that these acts happened. She disclosed to the social worker. She disclosed to 2 therapists over an extended period of time. She reported to her grandmother, and she wrote her personal journal. All of those were consistent that each of these acts happened
Okay.
And why?
So then, oh, excuse me.
Sounds like you're on a train of thought here.
I was headed to harmlessness.
That's
If you
where I
want to talk
was
about
headed.
error.
No, no.
Okay.
I was going to ask
Okay,
why
so,
it's not clearly erroneous.
so if we arrive at the conclusion it was a multiple acts case, you can
Right.
see there was error in not electing or instructing.
I do.
We all acknowledge the difficulty of a generic evidence case.
Right.
Now you wanted to talk about clearly erroneous.
Yes, Your Honor.
Okay.
Because the defendant never requested the unanimity instruction, then we have to look at whether it was clearly erroneous. And that standard is if the appellate court is firmly convinced that there's a real possibility that the jury would have rendered a different verdict. This case is similar to the State v. Colston case, and this court found that there was an error in failing to give the unanimity instruction, but that it was harmless when it was a general denial defense and it was a credibility contest, which is what this case was. It was a credibility contest between this victim and the defendant. And basically, this case encompasses that same situation, that the defense theory was, I was never alone, I didn't do it, and then he combined that the victim basically could not be trusted because the mother didn't want to pay child support and had fabricated this. The defendant was not misled in any way or prejudiced in making his defense by the allegation of when the crime occurred. He knew it was during this very specific period of time, from September of 2007 to January 3rd of 2008. There was sufficient evidence that the crimes were committed during the statute of limitations, that it was at one place. It's not like she was alleging it happened at the uncle's house.
It
and
was
then
in several different rooms, though, of the house.
it was in
So
different
there were
rooms.
there were some distinctions in her allegations.
Right.
There were different
agree.
acts, and there were different locations within the home.
I agree. And it was very difficult from her descriptions to determine which act happened in which room on which day. Correct.
Okay.
But there was significant evidence that each and every act occurred. The rape by digital penetration, the rape by penile penetration, the aggravated indecent liberties with the touching of the vagina, and the aggravated criminal sodomy. So the appellee argues that there was significant evidence and no real possibility that the jury would have reached a different verdict. So even if this court determines this was a multiple acts case, that in effect that there was sufficient evidence and that the error was harmless. And if there aren't any other questions.
I do.
Yes.
I
Yes,
want to
go
back
ahead.
up a little bit on the 6455 and how
Yes.
that came in at trial.
Mm-hmm.
I believe the victim in the previous case was JB. JB.
Mm-hmm.
So she was 4 years old when this alleged conduct took place in which the acquittal happened.
Yes,
And so 12 years later, she's now 16,
she was.
and she came in at trial and testified as to her version of events that occurred 12 years ago.
She also came in at the pretrial motions
I
hearing.
understand that,
Yes.
but yes, no, but at trial, I'm trying
Yes, she did.
to determine what the jury heard regarding this evidence. And who else came to testify about that?
Her aunt, and that was the resident.
That's the person she was staying with.
That's right.
At the time these allegations took place.
Right, and the detective.
And you're saying that was minimal evidence presented at the trial. The trial didn't focus on that. I'm just leery of that whole trial within a trial that happens when this occurs, and the distraction that the case at hand is the case that's before the court, and it doesn't have anything to do with what happened 12 years ago. And in a sense, you have a little mini trial going on there, in which the jury has to determine the weight of that evidence and determine whether it happened or not, and kind of relitigate that entire case.
Well, that's what 6455D does. Basically, it allows other extraneous information that can be brought in and reviewed by the jury, and the jury may discount it. The jury may not believe it. The jury may use it for anything that the jury believes as fact finder that it is probative to establish. But in the post-trial motions, the court in this case looked at the trial as a whole, looked at that evidence that was presented, and how the arguments were made at closing, and determined that it was a minimal part of the overall process in this case. So in some cases, I would agree it may turn into more of a trial within a trial, but in this case, I think that the court made the finding that it really did not turn into that in this case.
Any further questions?
Yeah, I want to ask you about a couple of rulings. One, the district court apparently mistakenly believed that it couldn't downwardly depart. Why? And we've said that if you do have the discretion and you don't realize you have that discretion, that's error, that is an abuse of discretion.
Yes, I understand
And
that.
am I viewing that situation incorrectly in this case?
My recollection of that is that the court basically said, legislature says this is really serious matter, and they've determined that it's a life sentence with mandatory 25 minimum, and I'm not going to dispute that, discount that, or look any further into that. I think it certainly would have been a better practice for the court to have taken the evidence in this case and weighed it with the mitigating factors and determine whether a departure would be appropriate.
So,
We should just
wasn't
rely on the
a,
transcript of what the judge said, pretty much. I mean, you can't really take issue with what the transcript shows about what the judge said.
No, I think that's very accurate. Yes, yes.
How do you respond to the issue about the 8 challenges for cause that were denied?
Well, first of all of those veneer members were stricken, so none of them ended up on the
Well,
jury.
my question is, if we find that the trial judge erroneously denied a challenge for cause for someone that says they can't be fair, why is it up to the defense to use its peremptories to cure a trial error? Do you understand what I'm saying?
I do understand
Okay.
what you're saying. I think then the burden is then on the defense to prove that the actual jury that was impaneled was not fair. And I understand your point that they basically use up one of their peremptories that they may have used for another reason. But I think that they are required to show that the actual impaneled jury was not fair.
But if someone says in a child sexual abuse case, I just can't be fair to the defendant, is that grounds for striking for cause?
The way that the judge viewed it in this case is if it were specific, they were a victim or an immediate member of their family was a victim of sexual abuse, then he believed that that was appropriate to strike for cause. But because there's a limited number of veneer members, every person basically that comes up there to be questioned says, you say it's a sex crime case against a child, and they say, I don't want to do that. I don't want to be a part of anything that's going to do with a child victim, and this is going to be really difficult. So the judge basically had to differentiate between those types of veneer members. Is a veneer member that's saying, I don't think that I can be fair. He always would ask questions. Will you follow the law? Will you do what the court requires you to do? And they would always say yes. When they said yes, even though they said it'd be difficult and they didn't want to be on a case with a child victim or a sex crime case, he would not permit the strike for cause.
any further presentation?
There is not, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
3 minutes for rebuttal.
Briefly, counsel has characterized this as a credibility contest, and it was that. But in order to just characterize it as a credibility contest, you have got to, counsel would have to ignore the testimony that goes to the specific dates of Roxanne, of Chris, of the younger brother, of the grandmother, who supported that a few of those dates.
It was credibility plus. It was credibility plus corroboration.
Plus corroboration, and the detective's testimony that went back and forth about the red blanket in the living room and whether that was adequately investigated. So there was a lot there. And Justice Johnson's questions that went to the challenges for cause. I don't remember the standard of review. It seems like it's abuse of discretion. It seems like it gets to a point when a court refuses to strike for cause and the defense uses many, many peremptories on those people that should have been struck for cause, understanding they are not getting onto the jury. Still, defense counsel made a record that there were other people that he would have used those chances on. And at some point, it seems like that becomes an abuse of discretion.
But how can we say, and we all know the drill, the judge says, well, will you follow the law and apply the facts to the law? Well, they're going to say yes. So how do you say that's an abuse of discretion?
I understand. And it's just simply not, it's the best system we have. It is not perfect. There's pressure on jurors to certainly attempt to the very best they can, even if they're unable. So that's all I have. Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.